What is the Anti-Kickback Statute? The Anti-Kickback Statute, or also abbreviated as the AKS, is a federal statute that prohibits giving something of value in exchange for utilization of government money. It's commonly seen with scams in the pharmaceutical industry, Medicare, Medicaid industry, and sometimes the defense contractor industry. Let's start off by talking about why is this even illegal? Because the AKS under the False Claims Act has a very strident civil component in which individuals who serve as whistleblowers who disclose these schemes have been eligible, have received in aggregate hundreds of millions of dollars, and probably are still eligible for many cases that are out there. But in addition to the civil component, it's treated very seriously by the federal government, and also there is a criminal component of the AKS. So anybody engaging in a pay-to-play type of scheme, either overtly or indirectly, and we'll get into the nature of these schemes in a bit, better watch out because there's severe consequences. Anybody knows about them, you should probably report them promptly, because if you're not part of the solution, I always say, the federal government may think you're part of the problem, and eventually these things do catch up. So what's the big deal? What's the big deal if somebody gives something of value for a Medicare or Medicaid patient to prescribe some sort of pharmaceutical product? Well, the problem is it completely undermines the integrity of the entirety of the system. Let's take the pharmaceutical example. So if a doctor has two equal products that it could be prescribing, and product A, there is no kickback, and product B, there's a kickback, who do you think most physicians will prescribe? They're going to prescribe the one generally with the kickback because it's in their economic interest. So both things being equal, there's a little bit of impairment of medical judgment because the physician's not doing it because of equality, which should really, he or she should prescribe one product half the time, one the other half the time, maybe as a personal reason other than the economic remuneration. But once you get that kickback involved, then all of a sudden the medical judgment is either directly clouded because of the kickback, or there's the perception of being clouded. So in that example, I used a 50-50 type of thing. Let's say product X is equally good as product Y. But what if product X is slightly inferior to product Y, but the physician then is receiving a kickback for it? How would you feel if your doctor prescribed you a slightly inferior product because it was in their economic benefit to do so? I think we'd all agree that's atrocious, egregious type of conduct when your health is at stake. So therefore, the AKS Anti-Kickback Statute really has strong tentacles to address this. If it's not directly something that impacts the patient's health, there's the perception that it just might. You want to make sure your doctor, your physician, your prescriber is doing it for your best benefit, not for their best benefit. Let's move on to talk about what can constitute a kickback under the AKS. Well, the first thing, the direct pay to play. Doctor, prescribe this product, and each time I'll give you an extra $50. How often do you think that happens nowadays? You'd be surprised. It probably happens every now and then, but the entities that engage in these schemes have become much more sophisticated. So they bury the kickback in a lot of different ways. And instead of giving them, for example, the physicians, the prescribers in the Medicare fraud, Medicaid fraud under the AKS, they do it in much more subtle ways. They'll be like, hey, Dr. Who, if you prescribe this product, Dr. Who, and you prescribe a lot of this product, you could win a free vacation. Where to? Ooh, the vacation, Hawaii? You prescribe an awful lot of it, well, you can take that vacation once a month. Something along those. Particularly if there's correlative effect to the amount of prescriptions that are written with the inducements given to the physician. So amount of prescriptions equals then benefit for the physicians, it's going to start to sniff like a kickback. There's also ruse titles. Like one of our cases that resolved last year for tens of millions of dollars involved a entity that was giving the individuals this wasn't a pharmaceutical, but this was in another healthcare setting. They were giving them fancy titles to have paper parties and just come in and sign all this different paper, not do any substantive work, and then pay them as their fancy titles. Let's say they were supreme leaders or some other title they were giving. I don't want to directly disclose what case that was, but they'll say, okay, you're now a supreme leader at this healthcare practice based upon the quantity of patients that you've sent to us. And it may not be in writing, but now come in and we're going to pay you as a supreme leader an extra $3,000 a week. And you come in for an hour and just sign this paperwork. Not really meaningful work. What's really fair market value, that's a concept in the kickback type of space, is the service that the individual's receiving, is that fair market value or well above market value? And if it's well above market value, that could constitute a kickback as well. Another hidden thing in the space is the also secret rebate. When an entity gives a rebate, so it's opaque, it doesn't look so clear to those on the outside. For example, if there is a product that's being prescribed and they go, okay, I will charge you $1,000 per pill because some of these new medicines are off the charts. You go ahead and charge the government $1,200 for that pill. After you get your remuneration from the government, I will then in turn kick you back a rebate, and of course they're not going to use kick you back. They'll say, we'll give you a rebate of $500 in 60 days. So there is an actual inducement once again to prescribe that particular product. And it's a little bit secretive, it's a little bit behind the scenes. You could also hear about these in outright paying for patients. Sometimes there's illegal runners used, in which we've had cases in which, quite frankly, illegal runners have culled and combed through homeless shelters in order to get people and work on their teeth. And for each patient that was scurried or scuttled to the dentist, they were given kickbacks of direct cash for those circumstances. A lot of kickbacks happen in the opioid cases and probably still do. Some of these cases have been stratospheric under the False Claims Act. There's a major pharmaceutical company. I won't name names in this particular video. Sometimes I do when we break down particular cases where there's a multiple billion-dollar settlement, and I believe it was like $500 million of that was attributed to the kickbacks for the prescription of the particular medicine. And we know this still goes on. We have cases in which, under seal, which we allege this still goes on in certain practices, and it could go on in the major pharmaceutical scheme, or it can also go on in a very simple individual healthcare practice scheme. One of the other questions that's ancillary to the Anti-Kickback Statute has to do with the Stark Law. And a lot of times violations go hand in hand. The anti-kickbacks, giving something of value to receive government funding type of cases. Stark Law has to do with self-dealing and lack of disclosure. So if you have a healthcare practice that refers all its patients to a chiropractor, for argument's sake, and doesn't disclose that they also own that chiropractic practice, that's a violation of self-dealing, and that would implicate the Stark Law. So ownership of practice number one shuttles all its patients to a derivative company that's location number two, so now they're double dipping. Again, how impartial and objective do you think that initial decision is to send that individual to that chiropractic clinic if they own that clinic without disclosing it? Doesn't that seem like a conflict of interest? Number one, that place may not be the best place for that particular patient, and it will always have the implications that that referral is tainted. And number two, even more so, perhaps they don't even need chiropractor services, or they don't even need that services they were sent out for, and it's just to enrich the core nucleus that owns the primary practice to get derivative billing, derivative funds for the benefit of that practice alone. And that's wrong. We talked a little bit about the Anti-Kickback Statute. Let me once again tie it into the False Claims Act. As a standalone statute, the government can take action without a whistleblower. It certainly has the criminal components, and whistleblower may sit back as the government investigates that. But really, if you want to harness the powers of the Anti-Kickback Statute, and if you want to harness the power of the Stark Law, you need to invoke the False Claims Act. The False Claims Act is the umbrella statute that has to do when the government's defrauded. And even though you may not think of a kickback as fraud, in fact, it's highly regulated type of fraud, and it could be considered a per se fraud. So if you have some sort of circumstances that you know about that doesn't smell right, doesn't sniff right, either explicitly as addressed in this video, or it's a little more subtle, because a lot of times it is more subtle with vacations, trips, sporting events, things like that, then you really should speak with an anti-kickback statute lawyer or law firm. Sure, we'd love you to speak with our firm, Brown LLC. I'll tout ourselves as one of the nation's premier whistleblower law firms, also ranked by Lex Machina as probably the second most prolific in the space over the last 5 to 10 years. But there's other good firms out there as well. You need to speak with a firm that has a focus of their practice on this particular space. Some of these statutes are complicated, labyrinth, and if you file them the wrong way, your case is over before it begins. If you want a free consultation about the Anti-Kickback Statute under the False Claims Act, what it means to you, and you don't want the FBI to be knocking on your door, speak with a lawyer today to understand what your rights are, what your exit strategy is, and hey, maybe the conduct is illegal, but most likely it's not if you know it when you see it and hear fact patterns along these way. So if you're listening to this video, as always, I thank you for taking the time. Leave a comment below, not about anything particular to a case. That you have to consult with a firm confidentially. But if you liked it, didn't like it, and what you'd like to hear me discuss next.